Hello there, my name is Jason Perkins, and I'd like to welcome you to another episode in the Georgia Workers' Compensation video series. I'm an attorney who specializes in Georgia workers' compensation cases. I created this series of videos because I want to provide people who've been hurt at work with helpful information about Georgia workers' compensation law and the benefits available to them under that law. Today, I want to talk to you about whether you can get Georgia workers' compensation benefits if you've been injured after violating one of your employer's safety rules. Let's start out by talking a little bit about what workers' compensation in Georgia generally covers. Workers' compensation in Georgia is generally considered a no-fault insurance system. To summarize that, what that means is it usually doesn't matter whether it's your fault, your company's fault, or nobody's fault that you got hurt, as long as you were doing your job when you got hurt. Workers' compensation generally covers on-the-job injuries, even if it may have been your fault. Maybe you weren't being careful enough when you got hurt. That's different than a personal injury type case where you often have to prove that it was somebody else's fault in order to recover any sort of benefits. In workers' compensation, fault generally doesn't matter, but there are some exceptions to that. Under Georgia's workers' compensation law, you are probably not going to be covered at work if you were injured through your willful misconduct. Willful misconduct can mean several different things, but one of the things it can include is your willful violation of an employer safety rule that results in your injury. But that violation has to be willful. If you were just being not careful enough, maybe being negligent, then hopefully you should still be covered under the workers' compensation law. But insurance companies won a case several years ago in front of the Georgia Supreme Court. They're now using this willful misconduct, willful violation of safety rule defense a lot more than they were beforehand. So you may be sent a form in your workers' compensation case, either in the mail or the insurance adjuster may notify you that they're denying your case because you willfully violated a safety rule. When the insurance company is asserting this, the facts as far as how the injury happened, what the safety rules were, how you were trained, all those things matter a whole lot. When there's a denial of your case, and especially where there's a denial on the basis of willful misconduct, I would encourage you to immediately reach out to an attorney and schedule a free consultation about your workers' compensation case, because you need to know what your options are in fighting this denial and whether the insurance company really should have denied your case based on what happened. Hope you found this information about whether you can still get workers' compensation benefits if you violate employer safety rule helpful. If you have, please let me know that. One of the best ways you can do that is by liking this video or giving it a thumbs up. If you've got some more questions about workers' compensation willful misconduct or any questions about Georgia workers' compensation law, one of the best ways to get those questions answered is by scheduling a free consultation with me about your case. There's two easy ways you can set up a free consultation. One is by reaching out to us through our website, which is www.perkinslawtalk.com, and clicking submitting the free consultation request form there. Someone from our workers' compensation team will reach out to you and be happy to schedule a consultation with me. The other way you can reach us is by calling the phone number on the bottom of the screen, and a member of our team will speak with you and get a consultation with me set up. I'd like to thank you again for watching this video today. I want to wish you the best of luck as you recover from your injury.